The Pollution Adjudication Board is a quasi-judicial body created under Section 19 of Executive Order No. 192 for the adjudication of pollution cases. The board is composed of the DENR Secretary as the chairman, 2 DENR Undersecretaries, an Environmental Management Bureau Director, and 3 others designated by the Secretary as its members. Some of the powers and functions of the board, as provided under Section 6 of Presidential Decree No. 984, are as follows. First, it issues orders or decisions to compel compliance with the provisions of the decree and its implementing rules and regulations only after proper notice and hearing. Second, it may alter or modify orders requiring the discontinuance of pollution, specifying the conditions and the time within which such discontinuance must be accomplished. And third, it issue, renew, or deny permits under such conditions as it may determine to be reasonable for the prevention and abatement of pollution, for the discharge of sewage, industrial waste, or for the installation or operation of sewage works and industrial disposal system or parts thereof. The jurisdiction of the board, it shall have sole and exclusive jurisdiction over all cases of pollution, including the imposition of administrative sanction except as may be provided by law. Some of the specific jurisdiction of the board are provided under the Clean Air Act, Clean Water Act, Ecological Solid Waste Management Act, and the Toxic Substances and Hazardous Waste Act. The rules of procedure. First, an interested person files a complaint with the board, the regional office, PENRO, or CENRO. If the complaint is proper, an investigation shall ensue. The party initiating the action shall be called the complainant, and the party against whom a complaint is filed shall be called the respondent. The second rules of procedure. A report shall be submitted to the board. If there is a prima facie evidence of violation, a notice of violation shall be issued. The third rules of procedure. An interim cease and desist order shall be issued if the pollutants constitutes an immediate threat to life, public health, safety, or welfare, or if it greatly exceeds the allowable DENR standards as provided in guidelines established by the board. The fourth rules of procedure. A technical conference with the respondent shall be held, wherein the latter shall be informed of his violations and be committed to his compliance with environmental laws. The purposes of the technical conference is for the simplification of issues and stipulation of facts, tentative computation of fines, and for the execution of commitment from respondent to abate or mitigate the pollution complained of, including the implementation of remedial measures relative thereto. The fifth rules of procedure. A compliance test inspection or sampling shall be conducted. If the respondent fails, the case shall be endorsed to the board for the issuance of a cease and desist order. The sixth rules of procedure. If the respondent has satisfactorily complied with the orders, his case shall be elevated to the board for computation and imposition of fines. The seventh rules of procedure. A summons will be sent directing the respondent to attend a preliminary hearing to discuss the violations, its evaluation, and its corresponding penalties. The last rules of procedure. The hearing shall be conducted and a decision shall be promulgated by the board or the regional office. For the venue, the hearing or deliberation of cases by the board shall be held at the main office of the department or in such other place as may be designated by the board. Subject to the basic requirements of due process, proceedings before the board and in the regional offices shall be summary in nature. The technical rules on evidence obtaining in courts of law shall not bind the board and the regional offices. The rules of court shall not apply in proceedings before the board except by analogy or in a suppletory character, and only whenever applicable. As the Supreme Court held in the case of Peza v. Pearl City Manufacturing Corporation, in administrative proceedings, a fair and reasonable opportunity to explain one's side suffices to meet the requirements of due process. The quantum of evidence required is substantial evidence, which refers to evidence that a reasonable mind could accept as adequate to support a conclusion. All documents forming part of the records and material to the issues of the case, whether marked as exhibits or not, shall be deemed admitted as evidence and may be considered in the resolution of the case. Documentary evidence may be received in the form of copies of excerpts if the original is not readily available. Upon request, the party shall be given opportunity to compare the copy with the original. If the original is in the official custody of a public officer, then a certified copy thereof may be accepted. The following are the related legal forms pertaining to the resolution of the case before the Pollution Adjudication Board: complaint, motions, pleadings, position papers, investigation reports, notices of violation, cease and desist order, show cause order, subpoena ad testificandum, and subpoena duces tecum, summons, orders, resolutions, and decisions appeal, and demand letter. Thank you so much for listening to our group presentation. Hope you find this material useful.